Yannick. He's first on the show. Hello. And he'll be a regular now. He's our litigation guru here. So we're going to talk about discovery and why it's important that you need to respond back to us. It's not that we're trying to be needy. It's not that we have daddy issues. But the big deal here is that you need to respond back to us whenever we're in litigation. And the reason why is because we have hard timelines. Yannick, if you want to kind of explain a little bit about the litigation process.
Absolutely. So when a lawsuit gets initiated, we typically send, discovery to the other side. They have generally 30 days to respond to that. So when they answer the complaint and they also what they do is called propound discovery upon the plaintiff, we also have 30 days to respond to that discovery. There's one type of discovery, though, which is a request for admissions that have to be answered in 15 days. And so that needs to be responded to immediately, because with admissions, if it is not responded to, then that side, the defendant, can actually seek to have everything that they stated admitted. And therefore, if it says something like, admit that you were not wearing your seatbelt, and we did not respond in 15 days, then for the purpose of the trial later, they can say it's deemed admitted that you were not wearing your seatbelt, and then that would go to the issue of comparative negligence.
Imagine that. You were driving your car, great day, it was not your fault, somebody rear-ended you, you had your seatbelt on, but you didn't respond whenever that question came up, and you just decided not to respond. So now they said, admit that you did not have your seatbelt on, you didn't respond within the time frame. Now you're admitting that you didn't have your seatbelt on, so the injuries that could have been prevented from the seatbelt are now being barred, or it's going to be an issue. So, for example, motorcycle riders, one of the things is wearing a helmet. It's a big thing, wearing a helmet. It's not required by law. However, if you don't have your motorcycle helmet on and you have a head injury, that injury is now barred. You cannot bring up that head injury because you wouldn't have had the head injury if it was for the motorcycle helmet. So therefore, all the injuries that you have to that is greatly reduced. Same with the seatbelt scenario. If you would have had your seatbelt on, you would have flown through the glass or whatever the case may be. So if it's deemed admitted, now those injuries are greatly reduced because you could have reduced the injury if you had just had the seatbelt on. And you probably did. Yeah. You just decide not to answer back. That's why these things are very important, especially on the request for admissions like Yannick was talking about. And we'll have different series on different parts of discovery and different parts of litigation. But on the admissions part, to his point.
And another thing about discovery, not just with request for admissions, but the other thing, request to produce that's more of document production. Sometimes there are things that we might not have gotten at the outset from the client. So getting in touch with you is very important within that 30-day time frame. Generally, the defense is going to be more lenient with that, but you still want to answer in time, because if it gets drawn out too long, they can drag us into court for a hearing, which wastes the attorney time. He's not able to be available to discuss the case and things like that with you or other clients because he's in a hearing. And if a hearing fails and then we're still unable to get production or get answers to certain discovery, the other type of discovery is called interrogatories, and I'll get to that in a second. If we're not getting answers, we've had a hearing, then they can actually go after sanctions, which would then cause us to have an expense to the defense, which would then make your cost of litigation or of your case actually increase. So then when you finally do settle or finally get a judgment, you're going to look at your settlement statement and say, wow, where did this, X amount of dollars come from? This $600 is because we had to pay an hourly rate to the defense attorney because we failed to respond in a timely fashion.
Yeah, what sanctions are, it's a penalty. It's basically like a slap on the hand, but hard. Because we got to pay X amount of dollars for every hour they had to prepare for their hearing, which could be pretty expensive. Like if you miss something and you're whatever, it might be $1,500, it might be $600. So it's really important when there's a hard litigation. It's a slow, fast process. It's very slow, but there's hard timelines, and when there's hard timelines, you got to hurry up. So it's very important to respond to us as quickly as possible to avoid all these additional headaches and costs that could occur just for not answering. We'll have different series on this litigation process, but if you have any questions, of course, you can give us a call. Our number is 833-4-BAD-DAY.